Okay, welcome everyone to IP at America's 250th. This is a panel that is co-run by IPPI, the IP Policy Institute at the University of Akron School of Law, and C4IP, the Center for Innovation and Promotion. We're joined today by four panelists who are experts in their areas of intellectual property, and we're going to be talking about the history of each of the major areas of IP in the US, what it has meant for us over time, what major changes have happened, and why we should care about it going forward. I'm Joshua Kresh. I'm a research professor and the executive director of IPPI, and I'll be your moderator today. With that, I'll start with our first question. America's 250th birthday is coming up, and IP has been an important part of our history from the beginning. For each of the four major areas of IP, starting with patents, when were they first protected in the US, and how is their protection important in America becoming what it is today? With that, I'll turn over to Andrei Iancu, former director of the U.S. Patent and Trademark Office under President Trump's first term, one of the co-founders of C4IP, and a partner at Sullivan and Cromwell. Andrei?
Great. Thanks, Joshua. Great to be with everybody again. I've participated in this program before, and it's a great program. You all do a great job organizing it, and I'm very thankful for the attendees for participating. Great question. It's actually a very relevant and interesting question, given that we are, as you indicate, celebrating our 250th anniversary since the Declaration of the Independence in this country. After the declaration was made in obviously July 1776, a number of years after that, the U.S. Constitution was created. As part of the Constitution, the founders saw it important to include what has come to be known as the Intellectual Property Clause. In Article 1, Section 8, Clause 8, giving Congress the power to create laws that protect, for a limited period of time, the exclusive rights of what they called authors and inventors with respect to their writings, which actually means artistic renditions. So that's the copyright side, and discoveries, which means the inventions, and that's the patent side. It is a very notable inclusion in the US Constitution. It's the first time a foundational document for a nation has an intellectual property clause. It is the first time that intellectual property was thought about as a rule of law in order to democratize creativity, innovation, and other artistic expression. It is a remarkable statement identifying that these are rights. You know, it's interesting. The US Constitution uses the word right only once, the Constitution itself, separate from the Bill of Rights, which came later. But the body of the Constitution itself uses the word right only once, and that is with respect to this intellectual property rights clause. It was that important to the founders. And what it has really done is generate a spark of creativity that humanity has never known. The amount of creativity, beginning with the United States and then expanding worldwide at that time, since that time, outpaces the rest of human history combined. And I don't think it's by coincidence. When you have a free market economy where people are free to choose where they spend their time and where they make their investments, in a free market economy, heavy investments in risky new adventures would be very difficult to do at scale without the protection of the rule of law. And what this intellectual property system has done is create at least three separate but equally important aspects that has created a spark of creativity and innovation. Number one, it incentivizes creativity and innovation because, you're spending your time in areas where you might actually benefit from later on. it it protects that innovation and investment in that innovation once it is made by the rule of law. And third, equally important, it creates a system of trade in that innovation, enabling that innovation to be transferred from the laboratory to the market, to be traded in the open free market system between companies and between inventors and consumers. It is a remarkably ingenious and efficient system that was created. And over the past 250 years, we see the spark in innovation that has created at mass scale. And that innovation keeps growing continuously, exponentially ever since. None of it has happened without the protections of the intellectual property ecosystem. So with that general overview, Joshua, I can stop and listen to the other panelists or answer any questions.
Thank you, Andre. I think I'll turn to Karen Temple next for copyright. Karen was the former registrar of copyrights and is an executive at the Motion Picture Association. Before that, I will remind the audience, or say to the audience, we do have ability to ask questions. If you put questions in the Q&A, I'll be monitoring those. And after I get through a couple more questions for the panelists, we'll turn to those. So please feel free to ask questions if you have them. With that, Karen.
And thank you, Joshua. It's a pleasure to be here today, especially with this esteemed panel. You as the moderator and my other panelists, Andre was the head of the USPTO and I was the head of the Copyright Office, so we were able to work closely together. So it's always great to be able to join Andre on a panel. And he did a really wonderful job of talking about the foundations of IP law, and I knew he was going to say that, so that's why I actually planned my remarks accordingly, because the fact that IP law, including patents and copyright law, was included in the U.S. Constitution as the very first article really truly does show how important IP protection was thought by our founders. So copyright history is uniquely American history. And so I just wanted to kind of go over a little bit of lore now that we have that overview that Andre so eloquently just shared. So in addition to the very first article of the Constitution, the first federal copyright law was also passed in 1790. So again, that shows how important our founders found copyright law to be for the establishment of our society. That statute was actually signed by our very first president of the United States, George Washington. Like most U.S. laws of the time, it was modeled on the British law in the case of Britain's Statute of Anne. And notably, I would say that the 1790 law is almost as old as America itself, but it's really much different than the copyright law today. At the time, it only protected three types of works. That was books, maps, and charts. And it had a very short term of protection, only 14 years initially, and then another 14 years. And there were various reasons, probably one of them our life expectancy at the time, for the limited term that we had at the beginning of the copyright law. And there was no U.S. Copyright Office at the time, no Library of Congress. The registration system didn't really exist as we know it today. At the time, registration took place in the United States district courts where the author resided. Interestingly enough, our first recorded registration was also in 1790, again, showing the importance of copyright law and the fact that it really has been part of our uniquely American history since the beginning. That was the Philadelphia Spelling Book by John Barry, which was registered in the U.S. District Court for the District of Pennsylvania and is, as I said, widely recognized as the first U.S. federal copyright registration. And again, these early steps really mattered because it created a national protection for authors in the United States, and it really showed how important, again, our framers thought copyright was to foster publishing, education, wider circulation of American creativity. As I note on the slide as well, it is recognized that the framers of the Constitution thought of copyright as the engine of free expression. And we all know how important our founders thought free expression, free dissemination of ideas was to our society. And again, they saw IP protection not as harming that or preventing it, but actually supporting it by allowing authors to be able to have protection and rights and incentives to create more and more. Today, of course, that means that our copyright industries, as being supported by the strong foundations that our framers first implemented, are really one of the success stories for American ingenuity and creativity. The U.S. copyright industries have contributed trillions of dollars in the U.S. GDP and are nearly 8% of our economy. We employ millions and millions of workers. And so again, that shows, I would say, the prescient nature of our founders in understanding how important it was that we were able to protect IP. And the fact that we did so, I think, is one of the biggest reasons why the United States both has the #1 copyright industry, but also the #1 technology industry as well. One other little factoid I would note that we did come a little bit late to the party in terms of the international copyright system. So although we had our very first copyright law right at the beginning of the U.S., in 1790, we actually didn't join the true international copyright system until nearly 200, I think more than 200 years later. So the Berne Convention, which was the major preeminent international copyright treaty, was adopted in 1886. With 10 initial countries, 8 founding countries participating. We did not join it. We were a bit of a rebel on the international copyright side. We created our own international copyright convention called the Universal Copyright Convention, and actually didn't join the Berne Convention. Even though it was adopted in 1886, we did not join it until 1989 for a number of various reasons. But I will say now that we have joined it, we have been a participant in the international copyright system for years. This is something where we again recognize the global nature of IP and the need to have an international framework supporting IP. We are now parties to all of the international copyright treaties, and we often include IP chapters in our FTA agreements as well. And in fact, in 1988, Congress did include IPR protection as a principal objective in our trade promotion authority for U.S. free trade agreements. So clearly this shows how important copyright law is and has been to the United States really since its founding.
Thank you, Karen. Turning over to Dave Gooder with INTA, the International Trademark Association. Dave was former commissioner for trademarks at the U.S. Patent and Trademark Office I believe when Andrei was there and Karen was there. So Dave, whenever you're ready.
We're out of practice of turning microphones on here. Thanks so much, Joshua, for having me today. And yes, I was the commissioner for trademarks when Andrei was director, and he twisted my arm to come there, and it was a great experience. Andrei and Karen have discussed IP rights that trace their roots to the U.S. Constitution, and what I'm going to do is talk about trademarks, which actually traces its roots more to commerce and the marketplace itself. And if patents represent sort of faith in America's faith in innovation, trademarks really represent faith in the free market. And that's really the story of American trademark law, because when you look way back in the country's history, it's really the story of how a country growing and expanding at the time, but quite young, learned how to trust commercial strangers as the country grew and expanded west. And trademarks were part of how that happened. In most jurisdictions around the world, trademark rights are acquired primarily via registration. But from a commercial economic perspective, businesses really acquire trademark rights by building goodwill and reputation. So following that theme in the United States, trademark rights arise primarily from use, not registration. In other words, in the United States, the market generally creates the rights, and the government later recognizes them via registration and then helps strengthen them by the fact of that registration. That distinction is sometimes surprising to lawyers from other countries who operate in registration-based systems because it turns the usual sequence upside down. But for much of American history, trademark law was primarily state common law and unfair competition law. And to the extent that there was any registration at all, it was a really fragmented and inefficient system. And then in 1946, the U.S. Congress passed what we call the Lanham Act, named after a congressman in Texas. The Lanham Act did not create trademark rights. Rather, what it did was it created a much more coherent national framework for rights that essentially already existed. This point's worth emphasizing because it highlights something uniquely about American trademark law, which, as I said, was that we create rights via use in commerce. But the Lanham Act actually went further than that. It created the legal infrastructure that allowed trademarks to operate on a national scale as opposed to market by market, state by state. It provided a comprehensive framework for registration, enforcement, unfair competition, et cetera. And perhaps most importantly, it proved adaptable enough that it continues to serve today as the backbone of American trademark law for nearly 80 years. So as America, I mentioned this sort of westward expansion. As America expanded, trademarks became the way consumers learned to trust purveyors of goods and services. It allowed them to buy products from people they never met nor would likely ever meet, because in the early days, you bought things from people you know who made them. So because of this, trademarks helped pave the way for essentially these localized markets to become national and eventually global. And as these distances grew further, consumers could no longer inspect every producer, visit every factory, or know every merchant personally. In this way, brands became a shorthand for that accumulated reputation. So while patents helped drive American innovation, trademarks helped American business become more scalable as they grew and expanded. And if I'm a script writer, my synopsis about this would read, the story of American trademark law is the story of how a young country learned to trust commercial strangers, and trademarks helped make that happen. Back to you, Joshua.
Thanks, Dave. And last but certainly not least, I'm going to turn it over to Vicky Cundiff from the University of Pennsylvania to talk about trade secrets.
Great. Thank you so much. So unlike the other regimes, there is not a czar of trade secret law in the United States. There is not a government office that supports trade secrets law, but the evolution of trade secrets law has been dynamic, going back well before the foundation of the country. In fact, trade secret law may be the oldest intellectual property regime. Some state trace it back to the ancient Greeks. It is also in the U.S. the latest regime to be the subject of federal legislation. Primarily over the years, it has grown through state laws. It has the broadest coverage of any of the intellectual property rights. Any kind of information, whether technical or business information, can be protectable as a trade secret. It's potentially eligible for protection. And perhaps because of that, it is consistently rated by business executives as the most valuable form of intellectual property, because the coverage is so broad, and also because in order to commercialize ideas, you have to share them. That may mean you're sharing them with employees, with investors, with counterparties, with business partners. And trade secrets law sets guidelines for sharing information safely. Trade secret law does not stand alone. Trade secret rights are often transitional rights. You may decide to protect information as a trade secret while you're deciding, is this idea going to work? Is it something that we may want to patent at some point in the future? And so there are limitations, but it is possible to begin protecting information as a trade secret and then to secure patent protection. And trade secret protection can stand alongside copyright protection. And of course, goods marketed that were created using trade secrets are going to be marketed under trademarks. So they all can coexist and the rights can be in tandem with one another. Trade secret rights are often transitional, as noted that as you're developing an idea or before you've released a product to the market, you may be able to protect it as a trade secret. Some can be enduring. Some manufacturing processes actually date back to the earliest days of the country when techniques for efficiently manufacturing potash were and to this day remain incredibly important. And interestingly, trade secret law, as it has developed in the United States, the remedies can be extraterritorial, and that is not always the case in full measure with some of the other IP rights. A very quick look at some milestones along the way. I mentioned that some trace the origins of trade secrets law back to the ancient Greeks, where it was essentially, they didn't use the term, but it was essentially a tort to induce servants of another to disclose information of what was going on within another residence. And the focus there was on protecting rights of confidence, confidentiality. That protection extended even to information that might not be viewed as a trade secret today, but the theme of protecting close obligations of confidentiality remains a bedrock of trade secrets law. And indeed, estimates are that between 85 and 95% of trade secret disputes arise with former insiders, employees, or former business partners. As time went on, trade secrets took on an additional character. In the guild system, information was transferred as part of the guild system, and that has always been a key aspect of trade secrets law, transferred in exchange for a promise to keep it confidential. In the United States, once we got past the revolution, there were trade secret cases decided under the common law, and it is said that the first decided trade secrets case involved the manufacture of chocolate, which is an interesting example of what can be protected as a trade secret. Making chocolate has been an art known back to early days in Holland, but figuring it out how to do it efficiently, how to have the best yield, how to make distinctive taste, that's been held to be a trade secret. And in the first trade secret case in the United States, what had happened was one of the early businesses sold the trade secret recipe and was shocked to discover the buyer was shocked to discover that the seller then wanted to continue to use the recipe, and the court said, no, it's a property right. He's sold it. He's forsaken his right to use it. A later case, also in Massachusetts under state law, dealt with processes for manufacturing a particular kind of fabric. And there, the employee had promised not to continue to use this method of manufacture after he left. And the court said that promise is enforceable. It's not taking anything from the public. The original company can continue to manufacture this way. And importantly, other organizations can try to figure out how to do it themselves. They can try to reverse engineer the process. They can independently develop something better, but the promise will be enforced. Over time, trade secret law continued to develop as state law. Eventually, the U.S. Supreme Court said that trade secret rights are not preempted by patent rights, that you're not forced to seek a patent for technical information, that you're going to have a choice. And the court said that patent law is a barrier. Trade secrets law is something of a sieve because it does have these outs, if you will. Others can reverse engineer or can independently develop, but it's of critical importance, often through licensing intellectual property rights and sharing them with others. And most recently, in 1996, the U.S. adopted a federal criminal trade secret statute. And about 10 years ago last month, Congress enacted the Defend Trade Secrets Act, a federal trade secret statute, which has been held to have extraterritorial reach. So the rights predated the country, and we're moving along, continuing to exploit trade secrets to this day.
Thank you, Vicky. Turning to question two, which again, I'll go through each of the areas. So what are the biggest changes that have been made in the past 250 years, to the extent they haven't already been discussed in the intro? And, we can talk about helpful ones or perhaps ones that haven't been so helpful. And I'll remind the panelists that question three will be on what we can do going forward. So if if you want to talk about something to fix, we can save that for question three. With that, Andrei, why don't we start with you on patents?
Sure. Just like with the early copyright statute that Karen mentioned, the first patent statute was the Patent Act of 1790. It was basically the fourth law that the country passed after the creation of the new government at that time, and patents were beginning to issue right after that in 1790. And there have been lots of changes ever since. Except for one major change that I'll explain in a minute, that has not one major issue that has never changed. But the changes in patent law over time have created what people talk about as a pendulum effect. Patent laws swing from being very pro patent owner protective to being very much in favor of consumer protective and therefore weakening patent rights. So therefore they swing between strong and weak patent rights over time. And the goal of administrators is to try to limit that swing and keep the laws somewhere in the middle. But for various reasons, there is a lot of push and pull in the patent system, IP system in general, and the pendulum swings. Um, I'll talk about this question, Joshua, in several categories. First of all, examination. So at the very beginning of the patent system, after the first laws were passed in 1790, it created a system of examining patent applications before issuing them. That's not necessarily an obvious thing to do. You could just simply issue patents any which way you want because you're friends with the person applying, or because the person applying is a big manufacturing company, or because you simply think, for whatever reason, this would be good for the economy or some other reason. There's not necessarily an obvious reason to examine applications for validity and other factors before issuing a patent grant. However, from the very beginning, the U.S. system created an examination system in 1790, where Thomas Jefferson actually was the first patent examiner. There was actually a board of three, but he was the chairman of that board. So those three folks would examine patent applications in their spare time. They were also busy running a country on with many other problems at that time. Thomas Jefferson and those three got tired of it, and for a while there was no examination, and that turned out to be a disaster. But the patent office was quickly created, and a patent office director was installed, and we generally have the examination system ever since then. So that's an important factor to keep in mind. Most countries nowadays around the world have an examination system in when it comes to patents, and I think, as you'll hear later, that's not necessarily true of some of the other intellectual property rights. Interestingly enough, in the 1800s, one of the things you had to do to obtain a patent is to submit a working model. These would be small models of your invention. They were miniaturized, but they were supposed to be working. And the patent office, during the examination process, would check it out and see how it worked and really understand a bit better than just simply having a paper record. And it's actually it's a fascinating piece of innovation history in the United States. Many of those models still exist. The Smithsonian has a bunch of them. The Patent Office has a bunch of them. But then there are private museums that have a lot of these patent models, like the Hagley Museum in Delaware. And unfortunately, the patent office burned about 150 years ago, and many of those models were lost, but many still exist. By the end of the 1800s, the system got to be too big, and they didn't have a place to keep those models anymore. So the submission of a patent model requirement was terminated in the late 1800s. I don't think that's a very important point one way or another to patent law, but it's an interesting fact of history. The next, the major change in modern times that is really important to the U.S. patent system is the Patent Act of 1952. It basically created the modern system as we know it today, by and large, of patent law. It crisply categorizes the basis for patentability into distinct statutes so that we can have an organized, systematic approach to analyzing patents, whether to grant a patent or whether a patent is valid after it is granted. So, under the 1952 Act, you first have Section 101 of the Patent Code, patentable subject matter. Is it in the patent system at all or not? Section 102, which is the novelty requirement, Section 103, which is the obviousness requirement, and Section 112, which is a bunch of formalities such as the claiming with definiteness, having sufficient and adequate written description and disclosure. So there are many other factors in the Patent Act of 1952, but it really organized patent law as we know it today. There have been changes at various times after that, but the other big change after 1952 was the America Invents Act, the AIA, which was passed in 2011, went into effect in 2012. And there were several major changes there. It turned the US patent system from a first to invent system to a first to file system with some exceptions. In the first to invent system, if you just invented first and you were able to prove that you invented first, you got priority of invention, even if somebody else raced to the patent office and filed first. We were the last country that had that system, and it's because, it's a cumbersome system to administer. It's hard to make that showing and to try to figure out who actually invented first, because humans very often invent the same thing at about the same time in many cases. So we went to a first to file system. So that means the first person to file generally at the patent office generally has priority. Again, there are exceptions and safe harbors and the like there. The second major change with the America Invents Act was to create an adversarial post-grant review system. They're called IPRs, inter partes reviews, or PGRs, post-grant reviews. And This has been a controversial change that the Patent Office and the patent system is dealing with to this day. But in any event, that system now is in force. A couple of other major changes relating to the courts. Okay, first was the creation of the Court of Appeals for the Federal Circuit in the early 1980s. And this is the Court of Appeals in the United States where all patent matters go. For everything else in US patent law, almost everything else, including copyright and trademark, trade secrets, virtually everything else, antitrust, doesn't matter, commercial disputes of any kind, they go to regional circuit courts, right? The First Circuit on the East Coast, the Ninth Circuit on the West Coast, the Fifth Circuit in Texas and the South, and so on. And in other areas of law, you have a competition of policy and ideas. And if two regional circuits disagree on a question of law, then that disagreement is taken up to the Supreme Court. That was eliminated in patent law for a variety of reasons. And now we have a unified system where all the cases and all the patent law issues get resolved at the Federal Circuit. Sometimes the Supreme Court takes an appeal from the decisions of the Federal Circuit. It happens, at least once a year or so, but it's rare because there is no competition of law and ideas in that system. The courts have also been responsible for some fundamental changes in law over time, and let me mention three that are most relevant today. First is Section 101, which is, again, patentable subject matter. That is the one statute that hasn't changed since 1793. The Patent Act of 1793 was written by Jefferson and Madison. It is the same as it is now when it comes to Section 101. Because Congress hasn't made a change, technology has changed dramatically since then, obviously. The courts had to step in, and the courts have created a new system of exemptions from the patent laws. So you cannot get a patent on what they call abstract ideas, natural phenomena, laws of nature. The cases there from the Supreme Court are Alice, Bilski, Myriad, and Mayo. And then there's a whole slew of cases from the lower courts interpreting those four Supreme Court cases. The second major change from the Supreme Court is in the area of obviousness. It's the KSR case. And basically, the Supreme Court created a flexible approach to determining whether a patent or a patent application on invention is obvious in light of a combination of existing other technologies. This has very much loosened the ability to invalidate a patent, therefore making patents from that point of view weaker than they were before. And the third area of law that courts have changed dramatically is in the area of injunctions. The Supreme Court about 20 years ago issued a case named eBay v. Merck Exchange. In the eBay case, said that to get an injunction, which is an equitable remedy, you have to show four equitable factors. The patent owner has to make that showing. And what's happened in the last 20 years since that case, the lower courts interpreting the eBay case has made it increasingly more difficult to get an injunction after the patent owner has proven that the patent is actually infringed by the other side. So let me stop there, but there are many other changes, but those are the major changes that have swung the pendulum back and forth over the last 250 years.
Thank you, Andrei. Karen, major changes to copyright law.
Yeah, and I think with respect to major changes to copyright law, there's a really clear theme. And that is the major changes occur when there is a technological change that needs to be confronted and addressed. So copyright law often has to evolve when the tools that artists and creators use evolve as well. And there are clearly several instances where the copyright law changed tremendously. First, after the 1790 Act, there was the 1909 Act. That act was signed by President Theodore Roosevelt. It was the first comprehensive copyright law of the 20th century. It did still retain the dual structure of kind of term, 28 years now, plus another 28-year renewal term, but it broadened protection. It introduced, for example, the first compulsory mechanical license for musical composition, and it represented the way that the creative industry had begun to be transformed by mass publishing, recorded music, and new methods of reproduction. So it helped adapt copyright law to an industrial and increasingly national media market. I will say one special time that was special to my heart was that motion pictures were first protected in August of 1912. The Congress amended the law to recognize motion pictures as a separate copyright category. Before then, films were typically registered just as a series of still photographs. They were a bunch of pictures in motion. This amendment gave movies the distinct legal recognition as a really separate and major creative and commercial form. And I will say, I love the quote by Harvard Law professor Chafee in 1945, which called copyright the Cinderella of the law. We often feel like patents and trademarks always get a little bit more attention. But his quote also noted how the law needed to transform because of modern technology. And again, that's a constant theme that we've seen since 1790, the need for evolution of the law to address technological advancements. And he noted that way back in 1945, the act was already 35 years old because we were operating under the 1909 Act, but the industry had exploded at that time. Again, his point remains useful that copyright law succeeds when we can absorb technological change without losing sight of the basic purpose of encouraging creation. Unfortunately, it still took us another 30 years for the revisions that he called for in 1945 to actually take place. The Register of Copyrights, Barbara Ringer, worked on the law herself for 21 years after joining the Copyright Office in 1949. So it wasn't until 1976 that we had the Copyright Act of 1976, which became effective in 1978, that we had the next full revision of the copyright law, that is the modern Copyright Act that we know today, even though they had been calling for revisions and updates to the law since essentially 1940. That act, the 1976 Act that we're under today, had some major changes to the law that we now really think of as critical to the U.S. copyright law and legal system. It codified fair use in Section 107, while still preserving it as a flexible and open-ended doctrine that the courts can construe. It also extended federal protection to unpublished works, and it modernized a broad range of creative expression and technologies. I will say, again, this theme with the copyright law trying to keep up with technology, though, is, still relevant to today. Barbara Ringer herself remarked that the 1976 Act, it was itself a good 1950 copyright law because of the amount of time it took for that law to actually be enacted. One other thing that I would love to note about Barbara Ringer herself is that she was the first female register of copyrights. And her background as a heroine for copyright law is particularly noteworthy because she actually had to sue for discrimination, both racial discrimination and sex discrimination, to get her position after she was passed over by a man. And a court ordered her installed as the register in 1973. And all of the subsequent registers really owe her a massive, massive thank you for all that she's done for copyright law. Since she was installed as the register in 1973 as the first female register, there have now been 5 women total, including myself, out of 14 registers, and the last 4 have all been women, and that is really thanks to Barbara Ringer. In terms of copyright law changes, we tried again to address another significant technological change when the internet exploded. And so we adopted the Digital Millennium Copyright Act in 1998. That was implemented as part of our extension to the WIPO copyright treaties. And it really was designed to allow us to address how the internet, how piracy and digital technologies have evolved. Again, however, technology often outpaces our ability to keep up in terms of the law. And recently, the U.S. Copyright Office has noted in their 512 report on the DMCA that the balance actually has been a little bit skewed in terms of how we want to address the protection and anti-piracy issues and the support for technology. They've noted that things have changed significantly, even since 1998 when the DMCA itself was adopted. When you think about the 1998 kind of framework and the technology there, you have to imagine that, download times were a fraction of what they are now. A 30-second movie clip in 1998 would take 30 minutes to be downloaded in 1998. And today that can be done in 30 seconds, as I mentioned. In fact, you can download a 4 GB movie file in 20 minutes. And a song can be a 4-minute song would have taken 80 minutes to download in 1998. And it today takes about 1 second. So that was the major update we had to our law in the current modern copyright history, but it itself hasn't really kept up necessarily with every technological change. Other major changes that we've had, in addition to the DMCA in 1998, we had the Sonny Bono Copyright Term Extension Act in 1998 that extended copyright protection by 20 years. I will say that you asked what was positive and what's harmful. I think that was a positive change to keep us up to date with the international framework, but some had questions about the need for term extension. So that was a bit controversial, but it was nevertheless an important amendment to the copyright law to keep us, with our peers around the world. As a result of that law, though, it did freeze what we know as the public domain, the ability to use works out of term from 1998 to 2018. So no new works entered the U.S. public domain between those years. It wasn't until January 1st of 2019 that works that were created in 1923 first started entering the public domain. Now, new works enter the public domain every year as they get older and meet the full term that we have. And now, actually, they even celebrate Public Domain Day every January 1st. And we've been able to see actually interesting works come into the public domain as a result of the Term Extension Act. One notable example is Winnie the Pooh. who went into the public domain. And now the public domain has allowed creative use, I would say, in an interesting way, of Winnie the Pooh with the horror film Winnie the Pooh, Blood and Honey. And because of the public domain, there has now been this Winnie the Pooh film, it's interesting. I'll describe it. It says the days of adventures and merriment have come to an end as Christopher Robin, now a young man, has left Winnie the Pooh and Piglet to fend for themselves. As time passes, feeling angry and abandoned, the two become feral. After getting a taste for blood, Winnie the Pooh and Piglet set off to find a new source of food. It's not long before their bloody rampage begins. That's the type of thing you can now do because of the public domain. Unfortunately, that particular movie only got 3% on Rotten Tomatoes. But nevertheless, it was a result of our Copyright Term Extension Act and the new public domain. Another copyright work that went into the public domain recently was Betty Boop. For some reason, horror films are what people do when a lot of characters come into the public domain. And in that case, there was another Betty Boop horror film that was created recently, where the synopsis is a team of horror podcast investigators breaks into an abandoned theater to discover the hauntings of the starlet, once known as Betty Boop. A simple investigation turns into a horrific bloodbath as they fight to escape the murderous Boop as she is out for revenge. Again, that is a horror film that came out of one of the public domain works. And I don't know what the Rotten Tomato rating is on that one, but it does show the creativity, I guess some would say, that exists when creative works sometimes come out of the public, come into the public domain. Other works that have come into the public domain now are The Wonderful Wizard of Oz, and in 2026, the first 4 Nancy Drew books came into the public domain as well. So while term extension when that happened was a bit controversial, we do now have a ready and continued source of new works coming into public domain every single year. And many people do celebrate that. And then finally, I'll just close with 2 final amendments that are really significant in the copyright field. The Music Modernization Act, which was passed in 2018, it really updated the law to make statutory licensing more fair and easy to do and more efficient for digital music providers. That was a very, very significant law to keep up to date with how online music streaming had developed over the years. And then most recently, we also amended the copyright law to, for the first time, have the creation of a small claims tribunal for copyright claims. That is something that is run now through the Copyright Office, where if you have a small claim that is under, with damages under $30,000, you can actually go and have that adjudicated in the small claims court at the Copyright Office, as opposed to having to go to federal court. It's designed to make copyright enforcement more accessible for creators who can't necessarily afford to be in federal court themselves. So those are the major, major changes that we've seen in copyright law over the last 250 years.
Thank you, Karen. Dave.
All right. Really, the history of trademark law changing over time is how it adapted to ever larger markets in the U.S. and globally. Local commerce became national, which became global, or multinational in many ways. And now it's all being impacted, of course, by AI. But regardless, the remarkable thing is that the core question about what trademark law focuses on, which is hasn't changed, which is how do customers know and trust who they're dealing with? I mean, that's kind of the bottom line of trademark law. So if you look across all these changes, and there's been a number of them if you look across the trademark ecosystem in the last few decades, here are what I believe are probably the six biggest changes that have come along. Obviously, the Lanham Act it was the sort of fundamental change, because we already had trademark rights, but as I say, it created this coherent national framework. And in many ways, the reasonings behind what they were doing, I think, may have also been in some ways less about trademarks and more about how they facilitated the growth of interstate commerce in the U.S. Inside the Lanham Act, there's been a number of significant changes, but I think probably the biggest one occurred in 1989 when the U.S. trademark law was amended to start allowing applicants to file in the trademark office based not on their actual use, but based on their intent to use a mark in the future. And that it did a couple of things. One, it helped businesses more proactively protect their rights as they develop products and new offerings and that type of thing. It also got rid of some of the workarounds, let's say, that people were doing what they used to call token use, and you'd ship a case of your product to your brother-in-law in another state, and that, you'd argue that was interstate commerce, et cetera. You got rid of all that. But the protection of business in the ITU system was significant, and that remains in place today. That also led to a growth in trademark applications. And if you look back over time, it's been a pretty significant growth. Trademark filings are essentially a bit of a leading economic indicator. And you see that when you compare the growth of trademark filings with the S&P 500, you really do see the Dow and all these, they track each other. And a lot of that was facilitated by not only the ITU system, but I think also because trademarks were just becoming a much bigger and bigger part of American business and were more recognized in how valuable they were. And that leads really to the second big change, and that is that the emergence of so-called national brands. The U.S. went through this era where the railroads had enormous impact, mass production, radio, television, all were just absolutely supercharged, based on way beyond what they were locally. And now we know them today as national brands. In fact, almost every brand almost immediately becomes national because of the use of the internet and websites, et cetera. So this made trademarks become these trust mechanisms, but operating at a national scale. And the value really wasn't in the symbol or the mark itself. It was in the reputation behind it. And indeed, if you talk to economists who are looking at companies and trying to assess value of a particular mark, or a product generally, often the trademark is considerably more valuable to the company over time than any other form of IP, partly because it doesn't expire if it's continually used. The third biggest change, I think, is what I would call sort of globalization. During the 20th century, American brands became increasingly multinational. Some even became truly global. And when I say that, it's very tempting for people to refer to their brand as global brand. Most often what that really means is multinational. There are brands that sell everywhere on the planet, but that's not the norm. But multinational has become sort of the much more the norm. So the expansion of trademark registries in other countries, and especially the international registration systems like Madrid, made trademark protection much more practical as people were taking their trademarks outside their home country or outside the U.S. to Europe, let's say, et cetera. But the one thing that you have to keep in mind about all this is that trademark laws are historically territorial. And that's based on partly because of the fact that the relevant inquiry is what do consumers think? And a consumer in Argentina doesn't necessarily think the same as a consumer in Brazil. And so while trademark laws are territorial, commerce increasingly isn't. And that creates a bit of a tension that has become sort of one of the defining challenges of the modern trademark system, especially for businesses selling or manufacturing outside their own country. The next big change really, trademark geeks like me could easily argue about the biggest disruptor to the trademark ecosystem since the Lanham Act. And then certainly if you get, 7 trademark lawyers in a room, you're going to get 8 opinions on which has had the biggest impact. But I think it's really, in my view, it's the internet itself has been the biggest disruption since the passage of the Lanham Act. Our time today, we don't have time to go into all the ways that the internet changed the trademark world, but suffice to say that for better or worse, it certainly did at least two things. One, it lowered the barrier of entry for entrepreneurs. And even big companies launching new products, but especially to upstarts, and enabled sole proprietorships, et cetera, to do far more, far faster than they ever could. Unfortunately, one of the other impacts it's had is that it lowered barriers of entry to counterfeiters, infringers, fraudsters, et cetera. So even so, the core trademark question, regardless of all that change, still remains the same. Can a consumer identify with confidence the source they think they're dealing with? The next big change, I think, is one that has erupted more so in the last few years. In fact, one of the questions in the Q&A gets at this, and that is this development, and it's the emergence of private sector brand protection systems in the form of brand registries and enforcement mechanisms that live on platforms that sell goods and services to people. And these are designed to help protect consumers and brand owners from counterfeits and infringement, et cetera. And I view these systems as complementary to what trademark offices do in terms of registration. They're not replacements for them. But 20 years ago, I think it's interesting when you look at this, take a step back. 20 years ago, when a brand owner faced a trademark problem, two of their primary questions were, well, what does the trademark office think about this particular trademark or the competitive one? And what would the courts think about that? Today, there's really a third question in there, and that's what's the platform think about it, or what will the platform do about it that it's being sold on? So, and this is fundamentally very new development in trademark history when you look over the length of time. The interesting question to me is not whether platforms will replace trademark offices. I don't think they will. The question is how trademark offices, courts, private sector brand protection registries, how will they learn to coexist for the benefit of not only the brand owner but consumers? Finally, while the dominance of AI impacts the trademark world is only a creature of the last few years, it's obviously having significant impacts. One of the biggest impacts I see is that consumers are increasingly interacting with AI before they actually interact with the brands. That's pretty different. In many instances, this means that the AI is actually becoming the influencer, such that consumers are, in a growing number of instances, not choosing amongst the brands available to them. AI is making that first cut. And that fundamentally, from a trademark perspective, really changes a lot of the game. Now, nobody knows how this is going to play out, but one thing is I'm certain of, and that is trademark law adapted over the years to introduction of the radio, television, globalization, the internet, et cetera. I think history suggests it will adapt to AI as well, and without fundamentally losing its core principles. Joshua?
Thank you, Dave. And you actually answered one of the questions in the chat, which is good because we're running short on time. We do have some questions. So Vicky, I'll turn to you, and I think we'll cap this at about 5 minutes, and then give everyone about 5 minutes for my last question, and then maybe I'll fold in one or two of the chat questions too, because we have 27 minutes to go.
Okay, great. So in terms of changes along the way, major changes on trade secrets law, I would think that actually, like trade secrets themselves, the evolution of the law in this area has largely been incremental. Over time, as commerce developed in the United States, industrialized states came up with rules for governing trade secrets law, which eventually were reflected in the restatement of unfair competition, the restatement of torts, and eventually became reflected in the Uniform Trade Secrets Act, which was adopted by every state except New York, and more recently in the Defend Trade Secrets Act. And the common thrust of all of these approaches has been the following: that first of all, as I mentioned, a wide variety of information can be protected as a trade secret, so long as it's not generally known or readily ascertainable, which raises interesting questions as we think about AI and what we can discern through AI problems. So it's not generally known or readily ascertainable. It has actual or potential economic value. And what has strengthened as a factor since at least 1974 is the information must be the subject of reasonable measures to protect it, not perfect measures. And courts have said over and over, you can't come to court as a defendant and say, well, I was able to get this trade secret and use it for myself, so it must not have been protected properly. The question is, were reasonable measures taken to protect the trade secrets? So just to note some highlights along the way, I mentioned that in 1974, the Supreme Court said patent law doesn't force a choice of, to say technical innovations need to be protected under patent law. You can elect to protect information that isn't generally known, that isn't revealed in your marketed product. You can choose to protect it as a trade secret. And that led to, it accelerated the codification of trade secrets laws across the states and ultimately in the federal statute. Given the broad scope of information that can be protected as a trade secret, I think businesses came to realize trade secret law may be a particularly attractive regime for new technologies. You come up with new ideas, you're not quite sure how they're going to develop, the parameters aren't quite clear yet. You may choose to protect it as a trade secret. But trade secret law is also very valuable for mature technologies, efficiencies, information that may not be something that you could ultimately get a patent on, but that makes the difference between the use of raw materials, the speed of production, the quality control. So both the mature industries and emerging industries turn to it. And also organizations have come to realize that where infringement is likely to be difficult to detect, trade secret law may be a good solution. I mentioned that one of the changes that has developed since at least 1974 is a focus on, well, how good were the measures? How reasonable were the measures that were taken to protect the information? And I saw that in the chat, somebody asked, well, is there variation between what the various US states require in terms of reasonableness? And the answer is really not. It's a question of what's reasonable under the circumstances. If you're a small company, and you're trying to protect a recipe and you've only got 8 people, you may want to protect your recipe by using coded names for the ingredients. You may want to have the recipe cards on note cards that are locked away every night. If you're a different kind of organization with different kinds of trade secrets, you might want a more robust approach, including even, for example, digital scanning of retinas before people can enter rooms for trade secrets are rendered accessible. And of course, that's an issue that also remains internationally. Various treaties in various treaties, countries have agreed to take reasonable steps to protect trade secrets, but how that plays out differs amongst different countries. Some take a very formalistic approach. Information has to be legended, stamped in a particular way. Others are more of a totality of facts and circumstances, which is the approach the US follows. The US has also clarified that there are 3 types of misappropriation: wrongful acquisition of trade secrets, hacking and similar means; wrongful use of trade secrets, which in the US is defined very broadly, that you don't have to copy a trade secret if you use someone else's trade secret to accelerate your development, The finished process or product may be different, but if it was the use of the trade secret was an important step along the way, that can be misappropriation. And of course, wrongful disclosure of trade secrets. So these elements have all been part of trade secrets law in the United States for a considerable period of time, but they have been codified. And the final thing that I would mention is that in the Defend Trade Secrets Act, there has also been an explicit look at one aspect of the public interest, which is there is a protection for whistleblowers. And so explicitly, and it is the only section of the federal statute that preempts state law, if the information was disclosed by an employee or an independent contractor to the government to report perceived wrongful acts, that disclosure itself is not a violation of trade secrets law. So these are some of the key developments along the way. There are many more, and we'll perhaps touch on them in our final remarks.
Thank you, Vicky. Okay, so turning to the last question, and I'll try to fold in some chat questions where appropriate. So for each area, what are the most important issues today, and what changes, if any, are necessary so the next 250 years are as successful as the last? Uh, One question in the chat was, why is it so hard to pass major legislation in each of these areas? I think that could be for proposing legislation. You could talk a little bit about that. And then Andrei, starting with you, a question in the chat talks about modernization and pendency at the PTO, which you may want to talk about, or you could say that I think the administration's actually done a pretty good job of solving some of that. So maybe we can talk about other issues that haven't quite been solved. Uh,
Yeah.
and I know you could usually talk for 90 minutes on this coming topic. So we'll try to keep it brief because we have about 20 minutes left.
Yeah, so it's a huge topic, but I'll be very brief. On the patent side, the most important issue for patent law, but frankly for some of these other areas of IP, is to make sure that our laws are modernized to keep up with the modern technologies. With respect to patents in particular, as I mentioned earlier, the foundational statute that defines what is in and out of the patent system was written in 1793 in the 18th century to address 18th century technology that were very much hard type of technology, industrial type of technologies, things that you can actually touch, that you could see visually, tangible in many respects. We are now in the 21st century, and technology is vastly different. It is an information-based economy, primarily in the United States and the West. With the advent of artificial intelligence, heavy-duty data processing, and the same thing on life sciences side, the analysis of DNA and the processing of DNA to generate new therapies. A statute that was written in the 18th century is having a very difficult time right now handling these 21st century technologies, and Congress must take up the question and see if it can modernize to address those issues. As just one quick example, data rights, data has no IP protection at all other than trade secrets. It doesn't qualify. Pure data doesn't qualify for patents protection, doesn't qualify for copyright protection. And that's a huge problem when a huge part of the economy is based on data and data processing. So this is key issue number one. Number two, issue that I believe is really important in the United States anyway, is the availability of injunctions for patents. And as I mentioned earlier, that right has been weakened by the Supreme Court case in eBay and subsequent lower court interpretations of that. And it is really hard to have a meaningful enforcement mechanism for a property right without the right to exclude. And there's lots of other things that are at a lower level, but let me just mention one final thing that's really important, and it does address one of the questions in the chat, which is the patent office itself. One of the biggest problems, in my view, is in the patent system in general are the ups and downs, the pendulum swing that I mentioned earlier on. And the huge component of that is the perennial changes in leadership at the patent office. It is, the leadership of the patent office is a politically appointed leadership that comes and goes with every administration and has wide latitude to interpret and apply the laws as an administration really should have. But the constant changes in leadership are disturbing are disturbing settled, the expectations of the economic expectations of industry. And this is important because patent rights are long-term rights. They're forward-looking. Investments are being made with many years of foresight, and having predictability is really important. And even though there is political leadership, other agencies in the US government have fixed terms, such as 5 years, 6 years. The director of the IRS is on a fixed term. The director of the FBI is on the fixed term. The head of NSF is on fixed term. Having the PTO, which is not a very partisan organization anyway, on a fixed term would be very helpful, in my opinion, to stabilize the system. Obviously, the director is still subject to dismissal by the president, but at least having a presumption of some permanence, and it would also avoid the many months of gaps in between administrations. To the question in the chat about pendency and the like at the patent office. To be honest, I don't think those are huge issues. I think they come and go, and US PTO pendency is not any worse at all than in Europe or other major jurisdictions. It has gone up in the past few years for sure, but it's now coming down, and I think it's just a matter of managing things appropriately. The office has done a very good job modernizing the institution, so I'm not very concerned by that. I am mostly concerned about stability of its leadership. And the final question, just to lead into Karen's, yes, I see it in the chat, and I say this with a half smile. Yes, Karen, the Copyright Office should be joined with the USPTO and create the US Intellectual Property Office. But I am half joking. I want to see what you have to say about that.
Thanks, Andrei. And yes, Karen, there were two ones in the chat that I thought you might want to consider focusing on. So one was the future of the Copyright Office, and then two, obviously the big one, AI and its impact on copyright. Of
Yes,
course,
and
very important.
I will say I wholeheartedly agree with Andrei on everything that he just said, including yes, it would be great to have a US IPO at some point, but that's not the current bill that's before us right now. But there is a bill to make the US Copyright Office register and director of presidential appointee with a fixed term to address some of the issues that Andrei had mentioned once that becomes a presidential appointee. So that does seem to be a positive step forward in modernizing the U.S. Copyright Office. I will say, modernizing the copyright law for evolving technology, as I noted before, and as Andrei mentioned just now as well, is something that is critical to ensure that the copyright law is addressing how creators work, how the creative industry has evolved, and to ensure that we can make the creative industry and keep the creative industry as strong as it has been in the past. So we cannot be stagnant in terms of our evolution of the copyright law. And I would say specifically two areas that obviously are probably on a lot of people's mind first, artificial intelligence, and then second, piracy issues. Also, on the artificial intelligence side, it doesn't necessarily mean keeping, the law up to date doesn't necessarily mean that there needs to be changes to the Copyright Act itself. It just means that we need to ensure courts are recognizing the new technology and are able to address that. So sometimes our copyright law changes occur through amendments to the act. Sometimes they occur through judicial action. In the case of artificial intelligence, for example, we started off slowly in 2020. I think there's only one case that was filed that really was looking at the issue of copyright law as applied to artificial intelligence and issues like training and whether the training to develop an AI system is fair use. And then steadily over the years, we've been seeing an increase in litigations filed under our existing Copyright Act to address these issues year after year. So again, 2020, we only had one case, and in 2022, it looks like maybe two cases on these copyright law issues with respect to AI. 2023 and 24 saw an explosion of cases. I think almost by more than 250%, according to some reports. So we had 25 cases filed in 2023, another 25 in 2024. I think 40 or 35 in 2025, and another similar number in 2026. So there are now more than 100 cases pending in the United States on the issue of copyright as applied to artificial intelligence. And so, yes, those issues are going to need to be decided. Again, not necessarily decided by Congress and a change in the law, but they will have to be decided by the courts so that the law can be applied effectively to this new technology. And another issue that I would just mention that the court will have to kind of grapple with is the human authorship requirement. Again, I don't think there's going to be a change to our law. So we're not going to take away the human authorship requirement. That's something that it goes all the way back to the foundation of the copyright law in the United States Constitution. But we do have to really figure out how we're going to apply that human authorship requirement in the context of AI. What level of human involvement is there going to be required to satisfy that human authorship requirement? There have already been a couple of cases on this. The Copyright Office has already issued some guidance as well as some decisions. And so you'll continue to see the law develop as technology develops to take into account that evolution on the artificial intelligence side. And then finally, on piracy, pirates are even using AI itself to evolve their piracy. And so we need to make sure that we are keeping up to date in our laws, just as the technology and the tools that pirates use is being kept up to date. We have to make sure that we're always a little bit ahead of the bad guys, so that we can make sure that the protection for IP that was foundational to the United States and to our framers continues apace. And I would say right now, one of the biggest changes that we do not have, that we need in order to ensure that we are kept up to speed with respect to how piracy has evolved, is provisions for no-fault injunctive relief. So I also agree on the injunctive relief side that Andrei mentioned with respect to copyright law. It's no-fault injunctive relief, or otherwise known as site blocking. It's something that we've considered in the U.S. in the past. We have not yet been able to enact legislation to create a site blocking regime in the United States, but now 6 60 countries around the world already have their own site blocking regimes, and they're actually getting far out ahead of us. So not only do they have kind of like standard static site blocking, but other countries are moving at the same pace that piracy is moving, and they're evolving even their site blocking regimes. So now not only do you have static site blocking, you have what is known as dynamic site blocking, you have live blocking. Recently, just last month, the High Court of Justice in the United Kingdom adopted procedures that streamline the blocking process for really clearly, blatantly infringing piracy services when they switch names or what we call hopping domains to evade court orders, because now they're using AI to be able to hop domains. And so they've created an even more efficient site blocking regime in the UK. Also, India last year has created a new site blocking system again to make sure it's continuing to evolve, and it employs dynamic blocking plus orders for registrars to suspend domains globally and provide key information to rights holders so that they can go directly after the illegal operators themselves. And that's known as the Indian dynamic kind of blocking plus suspension orders. So, we have countries who are recognizing the need to keep the laws up to speed with respect to protection and content protection. But unfortunately, the US is actually very behind in this area. And we have not been able to get something over the finish line in respect to site blocking in the US. I will say there is positive news, although we haven't yet crossed the finish line. Last January 2025, Zoe Lofgren, who used to be an opponent to site blocking, actually herself introduced the Foreign Anti-Digital Piracy Act to establish a site blocking regime, and it shows how the view of site blocking has changed after we've been able to see the experience in these countries that have had it. And Senators Tom Tillis, Chris Coons, Marsha Blackburn, and Adam Schiff, they also introduced or circulated a bipartisan bill called the Block Bad Electronic Art and Recording Distributors Bill, the Block Beard Act of 2025, which would also establish a site blocking regime in the United States. I know that that is being currently discussed as we speak. So hopefully the US, which is now a little bit behind other countries with respect to keeping up with the law on the content protection side, will be able to establish judicial site blocking in the United States soon and make sure that we are able to protect content even when facing the new evolution of piracy that is being supported by some of these new AI technologies.
Thank you, Karen. Okay, so it looks like we're going to run a little bit over, which I'm fine with extending, assuming the panelists are fine with it. For my WIPO summer school students and Akron students, if you leave at 2:30, because I know I'll see you back on in 15 minutes on Teams, you'll still be marked as full attendance for the session today, so don't worry if you have to jump off at the end. And Dave, I'll turn to you.
All right. Excuse me. Thanks. With regard to trademarks, if the first 250 years in the US was about how brands build trust and adapt to scale, the next 250 years is how do we keep that while the scale keeps increasing and more impacted by tech. So with that, here are kind of my top 5 things on what's coming and what we need to really look at and keep an eye on and focus on for trademarks as in the next years. First thing is that one of the great successes in the trademark system in the last century has been the growth of international cooperation. And I'd suggest that one of the greatest long-term risks to trademarks would be moving in the opposite direction. Trademark systems work best when they're predictable, transparent, and commercially focused, and they don't work nearly as well when they become instruments of nationalism, industrial policy, geopolitical competition, that type of thing. The next area is Trademark law has been, I think, successful because its purpose has generally been clear, which is help consumers identify the source, protect goodwill and investment, and prevent consumer confusion and deception, et cetera, in all that, in all its forms. But not every business problem requires a trademark solution, regardless of what a claimant might think. And one area where that tension increasingly appears is geographic overreach, or let's call it legal overreach, trying to shoehorn a problem with a trademark solution. And recall that trademark law is territorial. Commerce increasingly isn't. And businesses understandably want protection whenever consumers encounter their brands, but trademark rights have historically been defined by legal boundaries, commercial realities, et cetera. Now, we've all seen examples where trademark claims extend beyond protecting consumers and begin looking more like efforts to suppress competition, criticism, legitimate commercial activity, et cetera. So if trademark law is asked to do too much, it risks losing the clarity and legitimacy that have made it successful for so long. Quite simply, if we want trademarks to mean as much to future generations as they do today, we need to actively resist what I would call trademark overreach, whether it's legal or geographical. The next area is obviously AI, and it's probably the most pressing issue. Consumers are, increasingly interacting with algorithms, digital assistants, et cetera, and their recommendations. And for the most part, of trademark history, consumers evaluated brands directly. And as I said earlier, increasingly AI may be evaluating those brands on their behalf first. We can debate whether that's a good thing or a bad thing, but it clearly happens. It happened to me yesterday as I was looking for something. And this may prove to be one of the most significant changes trademark law has faced in generations. But we must be careful that we don't abandon our fundamental trademark principles simply because the technology is new. If I had to identify one practical and growing problem that deserves more attention, it right now is impersonation. Historically, trademark law was concerned with source confusion. Today, most of the significant fraud schemes you see involve identity confusion. And in essence, impersonation is a modern version of the same problem that trademark law has always addressed, and that's how do people know who they're dealing with. And impersonation has become easier and easier, and as it does so, the challenge is not merely detecting fraud, it's creating systems, whether they're legal, technological, or commercial, that help consumers recognize authenticity in all its forms before they are deceived. This impacts trademark offices, IP offices, it impacts consumers, it impacts businesses, it impacts law enforcement, et cetera. But in-person right now is one of the biggest reported crimes in the US. Looking farther ahead, way out ahead, commerce in space may sound like a bit of science fiction today, but so did global electronic commerce a generation ago. And indeed, many of the trademark issues associated with big technological shifts have ultimately been resolved through trademark principles. And we're going to need to maintain our focus on that as we travel into these new environments, et cetera. So I'll leave it at that for the moment. Joshua, back to you.
Thanks, Dave. And yeah, I think the commerce and space one could have a whole interesting discussion with the SpaceX IPO that's coming up any day now. But
Sure.
I'll leave that for another time. Vicky, I'll let you close us out.
So echoing some of the themes expressed by the others, I think a concern that courts are focusing on in the U.S. in the trade secret area is overreach. Because so much information can be claimed as a trade secret, sometimes organizations are claiming too broadly and too amorphously. And so, for example, to go back to our first trade secret case, if an organization were to claim that they had a trade secret about how to make chocolate, these days, courts would push back and say, well, what aspects of the chocolate production process are you focusing on? And I think that's a salutary trend to focus on what is it that you're trying to protect that is different from what is generally known. Don't claim too broadly. Claiming too broadly can stifle competition and can lead to overreach with employees if the argument is made that, well, this person learned about chocolate making for us, and so they'll necessarily be using chocolate making secrets if they go to another chocolate making firm. I think there is increasingly pushback on that broad acclaim, and that's salutary. AI is, of course, a critical phenomenon for us to grapple with in every one of these areas. And I think we should remember that at least some kinds of AI are generative. And so they can be creating new and very useful information. An issue that we don't have when looking at trade secrets laws, we don't have the authorship or inventorship problems that are being grappled with in the copyright and patent fields. Rather, one has standing to sue for trade secret misappropriation if they own the trade secret, regardless of how it was created. But that doesn't mean that we never have to think about how it was created or with whom it's being shared. So with AI, at least a couple of issues have already arisen in courts. One is, what if your trade secret is shared with a general public-facing trade secret platform? Well, at least one case has held recently that if you share with a publicly available platform, a chat GPT, then you are sharing it without restrictions, and you've lost control over your information. So there are ways around this. Some organizations have created enterprise AI systems, and some organizations are selecting based on the terms of use with AI systems that they may be using. So that's one issue, that can you protect information once it's shared with an AI tool? And another important analytical question is, gee, is more information going to be more readily ascertainable with these large language models and with various forms of AI? And I think the answer is yes. It is going to be more readily ascertainable, just as you could learn a lot more about customer information and manufacturing information once the internet emerged. And that's something that organizations are going to need to realize. Yes, less will probably be protectable. So when you're trying to protect information, focus on what isn't readily ascertainable. Focus on the nuances and the details. Courts are insisting on it, and I think that those who are creating trade secrets and trying to protect them need to think about that as well. And internationalism is, of course, and globalism, of course, is a continuing issue in all of these regimes. In the trade secret field, it is sometimes noted that if a trade secret is compromised in one part of the world, it may have been endangered in all other parts of the world. And that's why a number of decisions have read the U.S. statutes to say that a trade secret owner bringing suit in the U.S. may be able to obtain worldwide relief based on misappropriation. The efficacy of relief is something for a later day to be worked through, but certainly an issue that organizations potentially on both sides of the litigation need to be thinking about that. Much more to talk about, but I'm happy to close now.
Thank you, Vicky. And I will again thank all of the panelists. So thank you to Andrei, to Karen, to Dave, and to Vicky. I think this has been a great session that covered really the history of the major areas of IP in the US and gave people a lot to think about. We will also be posting a recording for anyone who missed part of it. You'll be able to catch up and feel free to share with your friends.
Thank you very much.
Thank
Thanks,
you for
everybody.
having us.
Thanks, Joshua.